Hello and good morning from Chicago. Thank you all for joining us today. My name is Chris Weed and I'm director of the Stigler Center. Today we are happy to host part 2 of our symposium celebrating the 50th anniversary of the publication of George Stigler's seminal article, The Theory of Economic Regulation. We have gathered a fantastic group of preeminent scholars to examine the theory and discuss its past, its present, and future legacy. Yesterday we focused on George Stigler's contribution and lasting impact. Today, we look forward to discussing whether and how the theory of economic regulation should progress to reflect today's market environments and political dynamics. For our first session today, we are thrilled to host Cass Sunstein for a keynote conversation with Filippo Lancieri. This will be followed by a panel discussion at 12:30 p.m. Central. As part of this symposium, we invite you to read a series of perspectives on the work of George Stigler on promarket.org. There you will find pieces from many of this week's panelists, with new pieces being posted throughout the month of April, including a piece from Cass and Filippo. To check out recordings from both days of this event, please be sure to visit our YouTube channel over the coming days. Before we begin, please note that we are on the record and the views expressed by the guests are their own, not those of the Stigler Center or the University of Chicago. If you have questions for the speakers, we will aim to address them in our limited time. You can submit them via the Q&A icon at the bottom of your screen. Please also do check out our website as well as our publication, promarket.org, and our Capitalism podcast. The links to these platforms can be seen in the chat function at the bottom of your screens. And now please allow me to briefly introduce our speakers. Their full bios are on our event page. Cass Sunstein is the founder and director of the Program of Behavioral Economics and Public Policy and the Robert Walmsley University professor at the Harvard Law School. And Filippo Lancieri is a research fellow here at the Stigler Center and a JSD candidate at the University of Chicago Law School. And now without further ado, I turn to you, Filippo. Thank you.
Thank you very much, Chris, and good morning or good afternoon to everyone from snowy Chicago. We are delighted to continue our symposium today with our second keynote speaker, who's Cass Sunstein. I think Cass really doesn't need any introductions. He's not only, we were particularly happy actually when he accepted to talk to us, not only because he's a leading scholar in administrative and regulatory law in general and all types of law, I would say, but also he's someone who made a lot of effort to really bridge the academia and policymaking. He first worked as OIRA, as the regulatory czar for Obama, and now he's in the Department of Homeland Security as well. And third, because Cass is also, let's say, a Chicago person, as Professor Douglas Baird said, and that he joined the faculty of the law school in '81, right before George Stigler won his Nobel in '82, so he overlapped a little bit. So Cass, I'll turn it to you, and we are delighted to host you. Thank you very much.
Thank you so much. It's a great honor to be here, in part because I get to see my great friend Richard Epstein, and in part because George Stigler was and remains a hero. As Filippo mentioned, I'm now working in the Biden administration on regulation. These comments will be entirely independent of that. I am speaking as a Harvard faculty member on leave, and in my heart, always also a University of Chicago faculty member, I like to hope, on leave. And to the extent that I'm speaking of regulatory experience, my focus will be on a prior incarnation as government employee and not the current period. In 2010, the Department of Justice issued new regulations under the Americans with Disabilities Act. The regulations establish requirements for courtrooms and detention facilities, boating facilities, swimming pools, and play areas. That happened. The next year, the Department of Transportation issued a passenger protection rule that prohibited post-purchase price increases, required carriers to provide passengers notice of flight status changes, such as delays and cancellations, and enhanced protections in oversales protections by increasing the maximum denied boarding compensation that airlines have to pay to passengers who are bumped from flights. In 2011, this isn't ancient history, the Department of Transportation and the Environmental Protection Agency issued new labels on motor vehicles. This is a regulatory requirement whose consequence you can actually see when you buy a new car. In 2012, the Department of Justice issued a final rule regulating correctional facilities to reduce sexual abuse. The standards cover prevention, detection, and responses to sexual abuse in multiple ways. In 2015, the Environmental Protection Agency issued a final rule designed to reduce greenhouse gas emissions from stationary sources. The rule was opposed by numerous electricity providers who vigorously objected to the costs. This is not a list of all regulations issued in the last decade or so. They're just illustrations of thousands of regulations, 2,403 to be exact, in which I was involved as administrator of the Office of Information Regulatory Affairs about a decade ago. Experience then as now makes it exceedingly hard to credit Stigler's claim that, quote, as a rule, regulation is acquired by the industry and is designed and operated primarily for its benefit. That claim is false, even a fairy tale, although a grim one with a capital G. It's true that Stigler was on to a real phenomenon, and there would be much less ground for objection if he had declined to speak of a rule and said more cautiously that in some important cases, regulation is acquired by the industry and designed and operated for its benefit. Even so, that raises the question, what does acquired by mean? That's a singularly ambiguous concept, and we want to distinguish, I think, between legislation and regulation. In my view, Stigler was right to draw attention to the possibility of cartels in the closet. That is an advance, but his essay was less empirical social science than a kind of narrative, that is a story. There's a mystery about the enduring appeal of Stigler's article in view of its incorrectness with respect to the general rule. Its success and influence, I suggest, owed not a debt to its accuracy, but was a tribute to its iconicalism, its sense of knowingness, its smarter than thou, cooler than thou cynicism, appealing to many, its mischievousness, and admittedly, its partial truth. Okay, I want to suggest that we can take Stigler's essay as an inspiration for a positive note, meant to suggest a direction for future work. If regulators are mandating reductions in greenhouse gas emissions, calling for new safety technology in cars, or requiring passenger protections in connection with air travel, it's really likely that they believe that the regulations are a good idea, all things considered. They might well believe that the regulations would have net benefits as required by prevailing executive orders. They might believe that regulations are desirable on distributional grounds, or they support some goal associated with equity. For example, they might help people who have mental or physical disabilities. A question which I think some of Stigler's work on information puts in a spotlight on is, why exactly do they believe such things? There are two main answers. The first involves the economics of information. What do they learn, and from whom do they learn it? In some cases, the industry is relevant. There might be something like epistemic capture. In other cases, journalists matter. Newspaper stories can attract regulators' attention. Think tanks, public interest groups, and academics even may matter as well. Some regulators live in echo chambers, others emphatically do not. In some cases, it might be helpful to speak of epistemic capture, which occurs not when regulators are literally pressured or when there's some kind of deal, but when what they believe to be true is only a subset of the truth or not true at all. So that's a point about the epistemology of regulation. The second answer involves the motivations of the regulators. What do they want to believe, and what do they want to dismiss? This is a question on which we have less information than we should. To see the importance of this question, consider improbably, and with your indulgence, the key moment in the development of the screenplay for Return of the Jedi. For those of you who don't know, that's the third Star Wars film in which George Lucas, the mastermind of the series, had a heated debate with his brilliant collaborator, Lawrence Kasdan. Kasdan strongly advised Lucas, "I think you should kill Luke and have Leia take over." Lucas promptly rejected the idea. Kasdan responded with a heartfelt claim about the nature of cinema. He said to Lucas, "The movie has more emotional weight if someone if you love is lost along the way. The journey has more impact." That was his claim about the nature of art. Lucas's response, bearing on regulation, was quick and unequivocal. "I don't like that, and I don't believe that." Notice, if you would, the sequence here. Not liking precedes not believing, and helps account for it. As for the plot of Star Wars movies, so for regulations. Whether people believe that may depend on whether they like that. Understanding what people end up hearing and crediting, that's the epistemic point, and also what they want to hear and credit, would enable us to make real progress in specifying the mechanisms that lead to regulation. Thanks.
Thank you very much, guys. I think these are terrific initial remarks. And if anyone has questions or comments, feel free to use the Q&A. And I think now we'll move to a more engaging discussion. So yesterday we covered a bit, for those who are here, I think the shortcomings and the merits of Stigler's article and some overclaiming and things like this. So I think we can put that aside for the purpose of our discussion now, given that the topic of the second day is to think about regulation moving forwards. So I wanted to start by asking you, so you recognize, and I think everybody recognizes, there's a distinction between some form of epistemological capture that's more associated with information asymmetries or ideology or shortcomings in how the regulatory process is made, versus like this more traditional capture that's some form of acquisition of the regulation by the industry. And to Stigler's credit, I think when he was writing, most of the regulation was like trucking regulation that he describes, or railroads or things like this. And then only later you're going to see the rise of environmental policies and these more broader regulations, as broad interest regulations. So do you think there is a way that we can identify in advance market characteristics or the characteristic of the regulation that increase the risk of this like capture, narrowly defined as the Stiglerian view of companies acquiring the regulation, versus these more broader issues of information asymmetries and epistemological capture?
I think James Q. Wilson's old idea is still a good avenue, which is that in cases in which the regulated entities are well organized and able to communicate with each other, in which the victims or beneficiaries are poorly organized and dispersed. Those are the cases like occupational licensing cases where we're likely to get old style regulation and old style Stigler type regulation. I think for occupational licensing, his principal exhibit, there's a lot of power to his case, and the features of the market are highly relevant there. For the epistemic capture, it's hard to speak abstractly because a great deal depends on the pre-commitments of the regulators and their bosses and to whom they are speaking and whom they credit. So if we think of, let's say, food safety regulation, you could imagine people of a certain kind finding interesting and credible the views of those who say this food safety proposal is really dumb and it's just a way of imposing costs because of a baseless fear, and others thinking that, oh my gosh, some people are going to die, maybe a large number, and the people who are dismissing the evidence are self-interested. So both of those cases could plausibly be ones of epistemic capture. And offhand, there isn't a simple intuition apart from antecedent policy judgment or political conviction that would put structure of the problem there. But maybe someone can do better than I just did.
Okay, no, I think that's interesting. So let's try to dig a little bit further. So you mentioned how exactly, what does it mean to acquire regulation, or what is this process of acquisition? And I think a lot of the time when we think about regulatory capture in the US, but also when I talk to Europeans, a lot of them immediately think about corruption or revolving doors. No, it's like, corruption or lobbying or revolving doors. And I see these as more akin to some kind of like soft corruption, that companies are spending money to somehow get the regulation they want to have. So do you think it's fair to make such comparison? Is there something distinct about capture that would separate it from corruption other than some kind of arbitrary legal treatment? Or, and what can be done to address this practice in real world policymaking, you think?
Okay, I want to go at this kind of sideways and think there's welfare increasing regulation, and then there's welfare decreasing regulation, and then there's welfare neutral regulation. Probably the third category is the smallest. And we want to know what are the factors that lead to the first. And offhand, at least in legal systems with which I'm familiar, soft corruption isn't the principal source, though it's an occasional source. So if it's the case that, let's say, some regulator has a climate change regulation that is, let's say, really weak or really aggressive in a way that, let's just stipulate, misses the mark, the idea that corruption is responsible for that it's possible, but it might not be at all true, and it's a little too easy and automatic. So the revolving door problem is real, and undoubtedly it's larger in some countries than others. I'd want to think not so much, I think, offhand, about banning the revolvingness of the door as the most effective remedy, though that has its place. You might want to have restrictions on what people can do before and after. That might well make a lot of sense. But to have institutional safeguards as well as, and maybe with even more enthusiasm now, institutional safeguards once people are there. So you could have, maybe this isn't the median person, someone who worked hard for industry X, who then goes working for agency Y, and the person's role is just different. And the person has no enthusiasm for, let's say, acting corruptly with respect to the old entity. The person has a new job. I want to see data on whether what I just described is too optimistic or whether that's the median case. You could imagine people who came from industry Y who were then really, really tough on industry Y, partly because of conscience, partly because of a fear of public perception, partly because of any number of things. So safeguards, yes, but the most productive forms of protection against welfare-reducing regulation seem to me to involve mechanisms that both elicit the dispersed information of the public, a Hayekian point about regulations that regulators may not know enough about, and second, a Benthamite point about getting a lot of technocratic expertise there about the likely consequences, let's say, of a food safety regulation.
Well, what would you think exactly will be the safeguards? Is it like strengthening, having a very like stable civil servant body that then moves, and you have just a couple of appointed political appointees that come from the industry, their leadership? Or is it something that you block people from lobbying in the same industry for a couple of years? Like, we're trying to think about the future of design. So what would you think would be these important safeguards?
Good, so let's set up an institutional framework for a nameless European country. I would focus on having people, let's say in the food safety regulation sector, who know a ton about what the most serious risks to consumers as a result of unsafe foods are, and who know a ton about the substitutes for those foods and whether they're safe, and to have economists there also who are really good at understanding how to think about welfare effects. So if you have the scientists and the welfare effects specialists communicating with each other, you are 3 steps ahead of the game. That's also protection against capture, by the way, but it's a protection against incompetence. So when I was in the White House before, the two of my favorite offices were the Council of Economic Advisors and the Office of Science and Technology Policy. And one reason I loved them so much is they were unpredictable. So the Office of Science and Technology Policy might say on Tuesday, this alleged risk is really modest. The agency's desire to regulate it isn't scientifically grounded. And then 48 hours, they'd say the agency is actually underplaying the magnitude of the risk. They should be more aggressive. And that's because they were technically objective to the extent that human beings can be, and they got people who really knew what they were doing. The Council of Economic Advisors might say with respect to regulation, this one has very high costs and the benefits don't come close. And for another, they would say in the same domain, actually the benefits are higher than the agency thought because the willingness to pay for X, which the agency leaves unquantified, actually can be quantified. And we're talking about a lot of euros. Let's turn it into European equivalents. So institutional design, I wouldn't want to say lots of civil servants and two politicians. The regulators in charge should be ones who are highly respectful, let's say, of what the technocrats come up with, though knowing that this is a democratic social order, not one where the experts get to make the decisions. So there may be some democratic reason to think something is better than what the technocrats come up with. The basic idea is that to the Stigler, I think, devotees, this seems impossibly naive, but beware of cooler than thou, more cynical than thou approaches to regulatory policy.
Okay, no, I think this touches on another question that I wanted to make, and a point that David Mitch is raising here in the questions as well, which is, so how do you see the role? We've seen a lot the rise of the cost-benefit analysis as a kind of a way to turn regulation more rational. And this is spreading throughout the world. I'm from Brazil, and Brazil is just trying to adopt a US-style cost-benefit system. Yeah, the cost-benefit analysis has been criticized by many as just being like a tool for deregulation. It's kind of like you always kill regulation and cost-benefit analysis almost. Let's put it like this, but the more progressive side. So how do you structure this review system that incorporates information? And then to David's question, that at the same time allows for major changes like you have changes in policy, right? You have changes in government, they have different political views, and they want to incorporate this into the system as well. So how do you think, what is the role of cost-benefit analysis versus other types of tools in allowing for these changes in ideology to still make some rational policy making that's not necessarily captured?
Let's have a first order and then a second order response. The first order response is that it's not at all true that cost benefit analysis is systematically a way to kill regulations. On the contrary, I was involved in over 2000, and I think all but one survived cost benefit analysis. And in many cases, under both Democratic and Republican administrations, cost benefit analysis is a spur for regulations, not a check on regulations. It's often a check on regulations, but everything depends on the numbers. So if you have a regulation, and I'm giving a stylized version of one that I dealt with about a decade ago, where the political process didn't want to do it really, including inside the executive branch, but the technocrats said, look, you're going to save a lot of lives and it doesn't cost much money. And then the political people just turned around. They said, what are we here for? Of course we should do this one. So that's the first order response. The second order response is it can be that the political types would have some override of what the cost benefit analysis shows. The Trump administration had this 2-for-1 policy where you have to get rid of one if you have to get rid of two if you're going to introduce one. That led to the lowest net benefits of regulations in recorded history, the lowest by far in recorded history. Now, fortunately for the Trump administration, recorded history doesn't go back all that far. It's only a couple of decades. Still, the 2-for-1, which was bypassing cost benefit analysis, that led to some bad things. A really bad thing, very low net benefits, welfare losses, opportunity costs in terms of welfare. Okay, another thing to say that's fair is that it may be that the cost benefit analysis is politicized itself, or it might be that it's incompetent. Both of those things are possibilities. And then for the incompetence, we need either judicial checks on incompetent cost-benefit analysis, and in some countries we've seen that, or we need, self-improvement, or we might need something else that's a filter to protect against that. If there's a political override of the cost-benefit analysis, by which the politicians say, fix the numbers so that it looks better, I think that's a good basis for resignations. That would be a very bad thing to do. Then there's something else that's a little more interesting, I think much more interesting, which is the Trump administration disagreed with the Obama administration about the benefits to consumers of fuel-efficient cars. Where the Obama administration thought that the benefits to consumers were very high. They were going to get cars that would cost more upfront, but save them a lot of money over time. The Trump administration's people were skeptical about that conclusion. This was an honorable, at least in writing, this was an honorable debate where there was data that cut both ways, and the Trump administration believed some, the Obama administration believed others. Honorable debates of that sort about how to value, let's say, consumer welfare loss, that is inevitable given the uncertainties sometimes the valuation of costs and benefits runs into. I wouldn't call that an objection to cost-benefit analysis. I'd say it means that, my friend Richard Epstein and I, we might both across certain territory like cost-benefit analysis, but we might disagree about what are the most credible assessments. That's a good discussion to have.
Okay, and then I think when you mean resignations, are you talking mostly about the interfering in the technical process? So in a way that you try to revamp the technical process, but you still would have some kind of political ways that Congress can just change policy, right? Or just to clarify this point.
Yeah, Congress could, but that's sometimes challenging in some nations. No, what I mean is if a political person tells a technical person to lie about the numbers because that's politically preferred, that's grave. That's a very grave offense.
Okay, and then I think this brings us to another topic that I wanted to cover, which is the question of this epistemological capture that you discussed, which is this idea of like you don't capture by acquiring, by spending money, but by controlling the information world and what kind of information is processed to the regulators. And then so I think a major problem in a lot of these newer, more complex regulatory regimes, and I work a lot with digital markets, for example, is that most of the information normally resides on the very company that you're supposed to regulate. So you need to develop a system that enables the production of this information at the same time without giving too much opportunity for the companies to just like shape the informational system. So what has been your experience with that, and how do you see this moving forward, if you have any thoughts to share on it?
Let's talk in terms of regulatory instruments. So one advantage of economic incentives, as opposed to, let's say, performance standards, is that they don't demand as much in terms of resort to information peculiarly held by industry in order to be developed. So if you have an economic incentive that says, a tax of some kind or a cap and trade, that can be devised without relying as much and as, let's say, credulously or skeptically on the information that the industry uniquely has. If you have a performance standard that, let's say, depends on what's the best available technology, a regulator may not know a whole lot about that and might have to depend on the representations of industry and to some extent speculate about whether the representations by industry about what's feasible are too pessimistic or not, which is a hazardous enterprise. There are some instruments like information disclosure and incentives that are less reliant on believing or not believing what the industry says. Now, if you have to do something that is in the nature not of an incentive or of a disclosure requirement, let's say an energy efficiency standard involving microwave ovens, and where the legal standard has to be what's feasible, then the only remedy is to have diverse people talking to the industry in a way that allows skeptical but respectful engagement about feasibility, where feasibility wouldn't be, would have welfare be the criterion, not feasibility, but feasibility might be legally relevant. And it may be that the industry undersells what it's capable of.
Okay, but these are open, and I think connected to this. So John Barrios has a question here asking about ideology and how this ideology is going to permeate through all of these. And it impacts cost-benefit analysis in his question. So how do you measure the costs and benefits? It's going to impact on what kind of information you're looking from the industry. And then Shola Kunal has also a connected question here, which is to what is the role you think of this retrospective analysis of regulation? So I think these are both like, I think ideology permeates in what kind of information we want to believe and how do we bring this information about. And then Shola's question is more like, what can we learn from the past? I think that this retrospective analysis is something that people always say and they always praise, but they do very little. And then, so how do you think this could shape and help us improve regulation more?
So retrospective analysis is extremely important and an excellent idea. And Executive Order 13563 in the United States calls for it. To say that very little has been done requires a comparator. Compared to the amount that ought to be done, that's fair. Compared to nothing, a lot has been done. So the number of regulations that have been scrutinized and rethought, let's say since roughly 2010, is really high. And some of that happened through a systematic process by which many departments reassessed many regulations and got rid of a bunch of them. Some of it happened in a more bottom-up, on-the-fly way in the last couple of years under the pressure of COVID, where the Department of Health and Human Services, among others, has said, gosh, a lot of people are at home, they can't come in. Are these regulatory requirements justified? And things have been taken away in a pretty careful way. I think just yesterday, this is the only thing I'm going to say about my current job, and it's completely public. The Department of Homeland Security posted a notice about assessment of barriers and processes in the context of immigration, what needs to be reassessed in a way that calls for public comment, that is engaging people who have experience with the system. And if you read it, you'll see it's an ambitious look back at things that are out there. We need to have more of that. I'd be very careful about the word ideology. It's awfully easy to resort to. If you have a system where people are, let's say, extremely cheerful or extremely sad about, let's say, trucking regulation, they think it's great or they think it's horrible, then their assessment of costs and benefits is likely to be adversely affected. But ideology, if it is driving regulatory whatever, that would be, unless the ideology is maximize welfare or something like that, the ideology is hooray or boo for regulation, that would be a problem that needs either preferably an institutional correction, if not, then a personnel correction.
But it's hard to completely get rid of it, no? Like ideology in a way reflects politics and the permeation of the system to politics. So Sam Peltzman had a piece for us discussing the Stigler, actually, right before your piece on pro-market, where he was giving the anecdote of when he was in the Council of Economic Advisors, and he was saying, everybody agreed that trucking regulation was horrible. But then the president just came in the room and said, the truckers are like, they're an important part of our political base, and so we're not gonna touch it. And then 4 years later, nothing had changed in terms of information, nothing had changed in terms of cost benefit analysis or anything that you could say. But then the political mood had changed, and then there was a revolution. And I think a lot of you say about the COVID, I think it's also true. It's like a lot of the regulations on telemarketing, on health, for example, everybody has been thinking they're a good idea in a way, but you could never break the interest group. And then somehow you need a major shift that allows you to break the interest group. So is there a way to shape the political process and the regulatory process to weaken this interest group influence or not?
So there were aggressive movements in the direction of allowing telework, telemedicine, long before COVID, and they were just introduced because they made sense. Not aggressive enough. I'd want to know more about that particular area. The idea that everyone believes that trucking regulation is a bad idea sounds a bit too abstract. We need to define the category. So there's safety regulation, there's truck themselves regulation, there's like speed limits, which are trucking regulation. So the abstraction doesn't seem quite right. If a president is saying we're not going to do this for political reasons, and in my 4 years, I didn't see that once. I didn't see President Obama once say we're not going to do that for political reasons. If he says we're not going to do it for political reasons, that might be terrible. It might be wonderful. It might be democracy in action. It may be some form of capture, not Stigler style, but some form of capture, or maybe even Stigler style. That would be, whatever our evaluation, that happened. I trust the story. And the question is, how can we reduce the likelihood that it happens with sufficient regularity that the regulatory process increases human suffering?
Okay, I think they meant at the time trucking language like minimum price, minimum fees, and like exclusive routes. But I wanted to conclude, and we just have a couple of minutes, and to understand better, what do you see as the role of academia in this whole process? And academia has always been seen as this independent area where, I don't know, smart people just give advice to policymakers or write theses on the ivory tower. But in the past years, I think in the past decade even, we've been seeing this growing engagement of industry and academia. So you see a lot of corporate donations, you see a lot of academics working as consultants, you see the rise of this industry-funded think tanks. So what do you see as the role of academia here? And is this something to be concerned about? And should we do more to protect the academia's independence, the independence of academia, let's put it like this, or not? So how do you see this discussion?
Great question. I'll tell you two stories and then be more general. So when I was in my previous government job, I testified on regulation, and there was some think tank document that had the word talking points in the upper right-hand corner. And it said something like Obama regulations have ruined everything. Because of Obama regulations, everyone is poor. Because of Obama regulations, no one has a job. Because of Obama regulations, everyone is dead. It wasn't that extreme. It was kind of like that. And a member of Congress, I don't remember the Senate or House, read the stuff. And I said with, something like bemusement, I said, I think it was the Senate, I said, Senator, I've learned in Washington that if there's some document that has in the upper right-hand corner talking points, that should not be taken as entirely reliable. And I meant it as, testimony humor. I thought everyone would laugh, but they all looked at me as if, what language is he speaking? So I thought, okay, welcome to Washington. So that's one story. The other story is, as a regulator in prior incarnation, and I'll say as a regulator now, when NBER posts its papers on Monday morning, it feels like Christmas. But there are a bunch of papers on NBER, working papers, that are somewhere between interesting and great. And they are, so far as I can tell, the median one. Forgive me, economists, if this is a lawyer's over-enthusiasm about economists, but the median one is actually credible. Might not be convincing, but it's credible. So for academics to do good work on regulation, particularly good work on what form regulation should take, whether it's the Department of Transportation or the Environmental Protection Agency, that's phenomenally valuable. And the fact that the academic might not ever see the impact that his writing has is beside the point. It's really possible that it'll have a very significant impact. And I have a higher taste, craving, I think is the right word, for academic research than maybe most regulators, but we're all trying to learn.
Okay, no, but I think final question here, but that's exactly why the industry is engaging academics so much. That's exactly why you see so many of these like industry-funded think tanks. So do you think that just disclosures are enough? Saying like, oh, this paper was received a corporate donation or something like this, or do we need to go further, something even further to protect the independence of academia? How do you see the trade-off here?
I think yes to the first, no to the first question, disclosure isn't enough. So we know from some work by George Lowenstein that disclosure is ineffective as a safeguard, at least in the context of medical advice. And a hunch is that's probably true here. But I'm not sure whether any step need be taken. When I say I'm not sure, I'm just not sure. I do think it's, there's purity and a kind of beauty in an academic article that is either not funded by someone with an interest, or if it's funded by someone with an interest, isn't at all affected by that. And whether you can tell whether it's one or the other, that's a completely fair question.
Okay, thank you very much, Cass. It was a pleasure to chat. And we're going to go into a short break, everyone, and then we will restart in 12:30 Chicago time. Thank you.
Thank you.
So we lose people.
Okay, I think we are ready to begin our next session. Welcome back. If you are just joining us, I am Chris Wheat, Director of the Stigler Center. We will continue today's session on advancing the theory of economic regulation, challenges and opportunities in just a few minutes, with a panel discussion with Professors Daniel Carpenter, Richard Epstein, Jennifer No, and chaired by Luigi Zingales. Before we resume, please remember we are on the record and we will post the video on our YouTube channel later. and that the views expressed by guests are their own, not those of the Stigler Center or the University of Chicago. Please submit any questions for the speakers via the Q&A icon at the bottom of your screens. And now please allow me to very briefly introduce our speakers. Their full bios can be found on our event page. Daniel Carpenter is the Alias Free Professor of Government in the Faculty of Arts and Sciences at Harvard University. Richard Epstein is the James Parker Hall Distinguished Service Professor Emeritus of Law and a Senior Lecturer at the University of Chicago Law School. And Jennifer No is a Professor of Law at the University of Chicago Law School. Our chair today is Luigi Zingales, Robert C. McCormick Distinguished Service Professor of Entrepreneurship and Finance at Chicago Booth, and Faculty Director of the Stigler Center. Without further ado, I turn it over to Luigi. Thank you. Luigi, I think you're on mute.
Thank you very much, Chris. And it's a real pleasure to moderate such a great panel. And I want to start right away with you, Richard. You joined the Chicago faculty around the time that actually this piece we're celebrating was written. Can you give us a little bit of a flavor of how was life back then, and also how was received when it came out back then? Richard, you're on mute.
I came to the University of Chicago in the fall of 1972, initially as a visiting professor, and accepted a permanent faculty position shortly thereafter. And at that time, there was a much closer connection between the law school and the economics department than there is today. We had a celebrated law and economics workshop, which was held in the law school. And there were four titans from across, or three from across the Midway, and one within the law school, who strode the earth. George was one of them. Milton was still on the faculty. Gary Becker was younger but very assertive, and Ronald Coase in his own way was powerful. And they were just joined by Richard Posner, who had come from Stanford the year before. And so the question about the mood of the particular time, I think what you have to do is almost go in the opposite direction from what it was that Cass did by talking about how things went in 2010 and 2020. If you go back, 3 of the 4 of these people all came of age in the New Deal. And essentially what they did was they reacted in very large extent to the kinds of economic regulations that took place at that time. On the normative side, there was, I think, a general sense of appalled behavior, given the fact of the dominance of cartel arrangements. And on the positive side, there was this constant effort to try to figure out exactly what form of cynical self-interest would explain the way in which these things were driven. To put this in a little bit more context, I think it's important to note that the first wave of regulation in the United States did not begin in the 1930s. It began roughly after the adoption of the Sherman Act in 1890, which was exactly the same year that rate regulation as a serious industry began. These things could not have happened much before, because the kinds of economies of scale that make either antitrust or rate regulation a credible kind of business did not exist until after the Civil War. And 1890 in many ways was the decisive feature. It was the year in which the Minnesota rate cases decided that you could regulate industries that have monopoly power. And the Sherman antitrust law was essentially a trust busted situation. If you take the next 20 or so years, it's interesting that Stigler and his company had relatively little to say about that, at least in the workshops that I went to. The reason, I think, is because these problems were difficult and there was no evidence of any kind of radical departure from sound principles. It was a tough debate to figure out whether or not you thought any regulation was appropriate for these kinds of institutions, or whether you would assume that monopoly power would somehow or other wither away. I think the better opinion was that a modest antitrust law with horizontal implications was probably desirable, and rate of return regulation was some kind of necessity. When you started to come to the 1930s, of course, now all of a sudden things start to change very powerfully. And what you see for the first time becomes the target of the wrath of George and company, which was the rise of regulation, which was a form of entry restriction that resulted in the creation of cartels out of what would otherwise have been some form of a competitive industry. The economics of this is very different from the economics of rate regulation and monopoly practices. The case for these regulations is very much weaker. And so what you could see was these people essentially responding to the kinds of initiatives that took place when they were students or graduate students. So there was a Motor Vehicle Act of 1935, which had as its profound objective to make sure that you not only determine the rules of the road, but you determine the composition of the traffic, who could carry what kind of commodity from what point to what point, required some kind of a license. This was easy ways to figure out how it was that you would get cartelization within some kind of an industry. Civil Aeronautics Act comes along in 1938. It has many of these same characteristics. The 1935 National Labor Relations Act was also understood as creating monopoly power. This was no great mystery at the time because in 1914, during the progressive reform era of Woodrow Wilson, one of the things that was done for the first time in American history was that we had different rules with respect to monopolization that applied to labor, which was generally given some kind of a free pass, and that which was applied to industry, where the monopoly-only restrictions of the Sherman Act was supplemented by Section 7 of the Clayton Act, which started to talk about actions that substantially reduce competition. So if you're trying to figure out what's going on here, as a descriptive matter, I think as a general proposition, you can say that the cartels that were created in these industries, I would add agriculture to them, are generally more inefficient than monopoly arrangements because cartels have additional restraints above and beyond trying to maximize monopoly profits. They have distributional constraints, which is very difficult for them to satisfy. Transfer payments are very difficult to make. And if you decide to give quota allocations the preferred solution, it means that inefficient producers are going to get a guaranteed share of the market, which they would never see otherwise. And so if you started to watch all these people in Chicago, there was a kind of a fervor that took place about them in the way in which they went after all of these things. And on the normative side, I think they all pretty much were the same. They concentrated somewhat on different industries. They were joined by Dick Posner, who had just written a very famous piece in 1969 called The Regulation of Natural Monopoly. And then what they did is they tried to develop a descriptive theory. And I want to stress at the outset that the idea that somehow or other well-congealed monopoly players are going to have a dominant position in this market, something which I think derived in part from the work of Manker Olson, which was done in 1965, was even wrong at the time that it was announced for a very simple kind of reason. Many of the most powerful industries that received protection were not large industries, they were farmers. A diffuse body of parties which were able to create all sorts of situations in which they rigged output within an inch of its life through the Department of Agriculture. There were also many situations, for example, in a case like Parker and Brown, where it was solemnly decided by the United States Supreme Court that if you had a cartel which had government backing at the state level, it could not be sued under the federal antitrust laws, which of course then created all these agricultural bodies which are still in place today. And so they had the normative theory and they had the kind of a descriptive theory. There was something else I think about the time, which in retrospect is very pronounced. 1971, 1972, these were very strong transitional years if you're trying to figure out that there's a new wave of regulation that's starting to come forward. So if you start looking back to the 1960s and so forth, and you see the kind of things that happen, 1962 brings you the modifications of the Food and Drug Acts and so forth, where very heavy increased requirements on what it is that you need to do to get a drug off to market. Not the kind of thing that George Stigler particularly worried about it. In 1964, we had the Civil Rights Act. And in 1971, the year that that statute actually came down, there was an important case called Griggs against Duke Power, which authorized a disparate impact case for race relationship, which all of a sudden did create a very heavy kind of technical, dense, mathematical, economic formulas to what sort of industries were overpopulated or biased distribution of one kind or another. Environmental regulation came up at that time. I'm thinking in particular, there was the NEPA statute, National Environmental Policy Act, which started to talk about massive disclosures with respect to various kinds of environmental hurts. 1971, there's a case called Calvert Cliffs, which kind of completely transforms the locus of power in a way that George might not have predicted and did not understand at the time. Namely, it allowed organized objectives to stop whatever it is that dominant industries wanted to do in the way in which they started to play the game. And how is this done? It wasn't done by politics, it was done by ideology. There was a very strong-willed, very able judge named Skelly Wright, who had come up to Washington, D.C. from Louisiana, and he was determined essentially to open up the process of regulatory approval to objectives And now all of a sudden what you do is you see something that George did not anticipate was beginning to form at his time. It's not just industry groups that start to become coherent. The cost of organization for other kinds of groups becomes much lower. And so now all of a sudden what you do is you see permanent groups like the National Resource Defense Council and so forth that come on with heavy specializations in various kinds of areas, so that what happens is the regulatory space now comes completely contestable amongst multiple kinds of parties, instead of being something that was generally governed only by the dominant industries about whom it might be credible to make a capture kind of case. At the same time, in the early 1970s, you start to see the erosion of these typical monopolies. The CAB was going quite strong in 1970. Alfred Kahn comes along, and by 1978 and 1979 in the Carter administration, you start to see substantial forms of deregulation starting to take place. So the landscape essentially shifted. But I would say in closing, because I think my time is probably close to up as a man who's sensitive to these kinds of things, George is like everybody else. You're extremely powerfully influenced by essentially the dramatic events of your youth, and that you're much less sensitive to the transformations that take place at some kind of a later age. That was also true about Ronald Coase, the way in which he thought about regulation and so forth. He was still worrying about the DC, the BBC and the FCC back into the early part of the 2000s and so on. What we have to do is to try to figure out what's best of what they said. And there's no question, as everybody understands, that George is not completely right, but he wasn't completely wrong either. So that the great challenge that we have in dealing with modern regulation is to try to figure out a comprehensive theory on the descriptive side, which will let you figure out which forces are likely to win and why, which is both an institutional and an intellectual inquiry. And then on the normative side, to try to figure out which kinds of regulations are desirable when we start moving away from rate regulation and price controls to the more modern issues associated with health, safety, environment, and the like. And so that, I think, will be the subject of our discussion. And I guess I now turn it over to Jennifer.
Thank you very much, Richard. Jennifer, you were not even born when Stigler was writing this, and you arrived to Chicago actually as a clerk for Judge Posner. So you got to see a later Posner. Some people say a gentler, kindler version of Posner. So given what Richard has said, I want to have two questions for you. Number one, how did you see Posner, the great Posner, that was part of that period and was, in a sense, an intellectual twin of George Stigler at the time, but by the time you clerked for him, I think it changed. And two, given that Richard has given this very important lessons that we respond to, is almost like a psychoanalytic version of economic history of regulation, that we respond to the regulation of our youth and we keep fighting it. You clearly are much younger, of a different generation. How do your generation that comes with a different view of regulation see Stigler's message today?
Yeah, so Richard gave this wonderful historical overview of the traditions of the University of Chicago. Indeed, as a current faculty member, I can report that they are alive and well. And, it strikes me in looking at the paper and in this conference today that, we would benefit even more from the interdisciplinary culture that we had, particularly, I think, with those in the public law side of things, because I think Stigler's paper is remarkably institution free. And I think having more conversations with those sort of thinking about the separation of powers and agencies would be useful. On clerking for Judge Posner, it was a terrific experience on so many levels. And I think Posner as a judge is different than Posner as an academic. So he was very careful, I think, to wall off that side of him when we were directly clerking for him. But that said, you certainly saw in action his application of law and economics principles to his judging work, and I think to his judicial work. And I think more than that, it was his academic appreciation for really getting at the truth and not letting outdated rules get in the way. So famously, for example, Judge Posner is not shy about, looking at Wikipedia, looking at the internet, looking out for what actually information is out there, rather than relying on these arcane debates between experts within the courtroom. And of course, more broadly, now turning to his academic work, a persistent theme in Judge Posner's work has been how to rationalize regulation, whether it's through cost-benefit analysis or in kind of thinking about risks, particularly after 9/11. He wrote a whole book about regulating risks and designing the Department of Homeland Security. So these are certainly themes that Posner continued to think about. And was it a gentler, kind Posner? I mean, I'll just say one anecdote here, which is when I went for my interview with him, I was terrified because, I expected to be, completely torn apart and, have this, contentious discussion about, you name it. But to the contrary, our interview was, there was certainly some of that. There was discussion of cost-benefit analysis and so on. But, a lot of it was, about his favorite movies, about tropes of various movies, and of course, his beloved cat, Pixie. So he was certainly a warm and kind person, just as a person. Now to your second question, and I know our time is brief, just about kind of the reading Stigler's work through fresh eyes. What struck me about it, amongst many things, is the extent to which his paper underappreciated the ways in which the market for regulation itself is regulated. And I think that's very much a post-Watergate, post-1970s phenomena. I mean, it existed beforehand, surely, but I think that piece of it is really missing. Indeed, to his credit, George Stigler is an economist, not a lawyer, and as befits an economist, right, he offers us this theory of economic regulation, the by now familiar view that we can think of a market for regulations where self-interested demanders, powerful industry groups, demand regulations from the suppliers. He's ambiguous, but he's really focusing, I think, on legislators rather than executive agencies themselves. And in doing so, you almost get this picture that, it's a perfect market, that it's almost, he uses language that almost makes it seem like there's an auction for, the market for coercive state power. I mean, a closer reading, I think, suggests more nuance, but I think that's the overwhelming picture that you come away with. And again, I think this really fails to appreciate all the ways in which, even in Stigler's time, the law, that is the courts and Congress, have really imposed various constraints on this market for regulation. Let me just give you a few concrete examples, okay? So the federal government in all 50 states banned vote buying in primary and general elections. These laws prohibit monetary and in-kind payments. The 1907 Tillman Act prohibits corporations from making direct financial contributions to federal candidates. Ethics laws in most states, if we want to talk about the revolving door, set mandatory waiting periods that range from 6 months to 2 years. Forget legislatures, the courts also regulate this market. For example, there's arbitrariness review under the Administrative Procedure Act, which essentially requires agencies to explain their decisions with public regarding reasons and explicitly to counteract the role of special interest groups in the industry. And then finally, courts have also liberalized standing doctrine to allow more parties, including consumers and public interest groups, to have more access to the courts. I think these observations at a minimum suggest Stigler's theory is incomplete. And again, maybe this is with post-Watergate kind of modern eyes. To be sure, Stigler recognized, to quote, that the political process erects certain limitations upon the exercise of cartel policies in the form of procedural safeguards. He talks about requiring outsiders on industry counsel, but he largely treats those controls as exogenous to the market for regulation. And I think his theory would really benefit from endogenizing the constraints on the market for regulation itself and to really ask the question, are the regulations that govern the market for regulations susceptible to Stigler's analysis? That is to say, and if not, why not? Why do industry groups have less influence in that realm relative to regulations in general? And briefly, I just wanted to emphasize just two other observations about the paper when thinking about this question. Okay, first is just to note the ways in which Stigler invokes both federal and state examples of regulation, right? He talks about oil import quotas, federal domestic airline subsidies, federal deposit insurance corporation, federal. But then his empirical examples are all about state regulations, right? So state truck weight limit regulations and occupational licensing are all creatures of state regulation. And I think in doing that, he really elides the important differences between the extent to which regulators can be captured at both those different levels. Okay, for example, state legislatures are, for the most part, part-time. That is, they rely on income streams from their other jobs. In addition to that, state judges are elected as well, so they are much more susceptible to capture than at the federal level. And in addition to that, administrative law is just not as robust at the state level. Some of them adopt a state level Administrative Procedure Act, but not all of them. And I think as a result, we have to do more work to figure out the application of the capture theory. And if we're focusing on the federal level, to appreciate, again, that the regulations of the market for regulations probably are more immune to capture because of the fact that we have Article 3 judges that are tenure protected, salary protected, and therefore will strike down the efforts of industry groups. For example, when the Chamber of Commerce challenged the Bipartisan Campaign Reform Act in 2003, the Supreme Court in McConnell versus SEC upheld the Bipartisan Campaign Reform Act despite the best efforts of industry groups. So the final analysis, perhaps it's best to appreciate Stigler's work for what he told us it was, which is a narrow theory of economic regulation, as the title suggests. And maybe that's limited to price controls, barriers to entry in established markets. It's not potentially an economic theory of regulation. Again, it's a theory of economic regulation, but it's not an economic theory of regulation understood broadly, whether we're thinking about social regulations or whether we're thinking about what I've been calling the regulations of the market for regulations, meta regulations, we might use that term. And to the extent it's been marshaled as a citation to engage in public rational choice as a whole, perhaps we just appreciate it as a mechanism for generating falsifiable hypotheses. That's all it is, that can be falsified by empirical work. And it seems fitting to maybe end with the words of Karl Popper here: whenever a theory appears to you as the only possible one, take this as a sign that you've neither understood the theory nor the problem which it was intended to solve.
Thank you, Jennifer. That was beautiful. Let's turn to Dan. And Dan, you were a student in the Poli Science department when Stigler was still around. And you are from the Poli Science department. So how did you see Stigler back then, and how do you see it today?
Thank you, Luigi. And just before I answer that question, let me thank Jennifer for her thoughtful remarks and Richard for his neo-Freudian interpretation of Stigler. That was great. I would say, so I never had the honor of meeting Stigler, at least not to my knowledge. My then partner, now wife, was in the economics department. Some of my best friends were in the economics department. And so I spent a lot of time wrestling with some of the different theories. Ed Glazer, I crossed paths with him a bit. So it was at the time when a number of the folks that Richard described were retiring, or and then a new generation of folks was coming in. But I will say that I spent a lot of time with this book, which contains a number of the essays, as well as, and it shaped my thinking a lot, in part oppositionally. Luigi, if you don't mind, I'm going to share some slides here.
Please.
I think you folks can see this. I want to give a couple of just overview points here that I don't think depart that much from what you've heard earlier, but are going to reflect a little bit of my own read of Stigler and this article that I've wrestled with for some time. I think it's important to understand that we use the term capture a lot, and Stigler really didn't. As he wrote, regulation in his model was acquired by the industry. He didn't rely on a language of capture, and I think that's important. That said, I think an error either of Stigler or of his readers that followed was to confuse, and I think this gets to Jennifer's point, anti-competitive capture with deregulatory capture. So I think the theory that we see here, the general outlines of kind of a political marketplace for protection, is helpful, say in the Grossman-Helpman sense for trade protectionism and for thinking about things such as licensing. Whether the actual licensing regressions do the work that Stigler wanted them to is another question altogether. I think it's far less helpful for explaining possible special interest or industry influence in therapeutic regulation. As Richard mentioned, the Kefauver-Harris amendments, which built on an earlier regime, much predating both this essay of gatekeeping in the 1938 Food, Drug, and Cosmetic Act. A pure, simplistic Stiglerian reading, and I'm not saying that Stigler himself gave it this reading, would say, well, that would be advantageous for incumbent firms or those who could expect to surmount those barriers. They would thus favor the regulation. Industry fought it all the way, and I've written a book on that. Similarly, the capture or potential capture of environmental protection by industrial interests. I think the industry aim here is often to weaken regulation generally, much more so, even if at the margin there is an attempt to erect entry barriers. But I think what we need, and this is part of the reason I'm going to thank Stigler, is I think we need a theory of Ralph Nader, or maybe if we don't want to theorize about him, ugly as that might be, of Naderist regulation. In other words, what happens when you get something like a populist and or progressive movement? How is it organized? How does it get votes? And how does it issue in the kinds of equilibrium institutions that one sees in, say, environmental regulation or therapeutic regulation? Think of the Pure Food and Drug and Cosmetic Act of 1906. Think of a range of other progressive era regulations like that. That's the direction, number one, in which I would point us. Number two, I think there was a tendency coming out of Stigler to engage in kind of a neo-functionalist analysis of regulation that got him and a lot of his later acolytes into some trouble. And this, I think, can be plausibly attributed to him. This is from an afterword to the Theory of Economic Regulation when it's republished in this outstanding book. And he says, look, the first purpose of these empirical studies, when we identify certain equilibrium patterns in the ways that the regulation allocates benefits and costs, is to actually work backwards and identify the purpose of the legislation. The announced goals of the policy, as he writes, are sometimes unrelated or perversely related to its actual effects. And the truly intended effects should be deduced from the actual effects. And you see a lot of people, including Kip Viscusi, write a couple decades later that this is exactly the kind of dynamic that explains any number of regulations, including things that you see for the OSHA cotton dust standard. And I'm relying a little bit on some work that I've done in the past, but it's actually pretty easy to come up with a theoretical model or a set of theoretical models that just proves this wrong. That you can have equilibrium industry protection for larger and older firms in equilibrium without any government preference, political preference for those firms. And I'm referring you here to an old piece I did almost 2 decades ago now in the APSR, an update piece in the Journal of Law, Economics, and Organization. And for those who wish, there's a recent extension of this by Henry and Ottaviani in the American Economic Review in 2019. But let me just say as a moment of gratitude that I think, and this is, I think, an extension of something that Jennifer said, what Stigler gave us was a falsifiable theory. We're all going to be wrong at some point. What we hope is that when we're wrong, that the process of proving us wrong leads us to advances in the sciences. In this case, the social sciences, the economic sciences, the legal sciences, what have you. I do think he actually might have had a point on the way licensing regulations were designed, although I think we need a much more careful empirics there. Some forms of screening, if you look at the research of Mark Law, an economic historian, I don't think the Stiglerian model applies, but I do think that if we were to look at the origins of institutions such as the licensing of barbers or hairstylists, well, I don't know what the research says. My hypothesis would be that Stigler might have a point there, not just in the evolution, but in the design of those institutions. More generally, I think what we've learned, in part by falsifying Stigler, is that capture happens less by ex-ante design and more by actually the metaphor he used, by the post-design acquisition of those institutions. And that was actually a point that was made 15 years before Stigler wrote by the late Marver Bernstein in a book called Regulating Business by Independent Commission, something I'm pretty sure that Stigler was familiar with. And he thought about agency life cycles, whereby basically agencies start as generally public interested in, generally more sort of aspirationally progressive, but they have to work with the industry in order to do their job, and they end up getting captured that way over time. It's similar to what James Kwok has called the cultural theory of capture or cultural capture. The problem is this is going to require a much more nuanced set of theories, equilibrium models, and difficult empirics. And I wonder, just going forward, whether we ought to ditch the term capture altogether. I've proposed half as much in a recent book with David Moss. I think the term is too sexy for its own good. Any regulation that we don't like or institution that we don't like, we often say, well, it's just been captured. Capture, as we argue in this book, is very hard to prove, not just because of omitted variable bias concerns or non-random assignment concerns, but because it requires you to come up with a counterfactual, namely, what would the pure public interest version of this regulation look like? And how can you prove, not just in an equilibrium model, but also with careful and credible empirics, that an industry interest or a special interest actually moved the state from that progressive counterfactual or public interest counterfactual to the captured state. There are, and I wasn't here, unfortunately, I had to teach right before this for Professor Sunstein's lecture. There are plausible informational, methodological, epistemological, or even cultural models of capture. I would argue those are even harder to prove. If we think somehow that the vocabularies or cognitive lenses of regulators are being captured, that's very alluring, maybe even as sexy as the word is capture itself. But proving that from the standpoint of the empirical social science is going to be hard. One thing I would focus on in the future is to focus on institutional closures versus cases where there are apertures. This is what David Moss and I in our book call kind of procedural red flags. So one thing we might want to ask are whether special interests are dominating procedure. And I'll point you to two recent papers, one by Brian Liebgraber that presents a fair amount of evidence that the notice and comment rulemaking process is being dominated less in the notice and comment stage, but by, at least in the case of Dodd-Frank, massive mobilization by large bank holding companies during the pre-notice and comment meeting stage. And then a recent paper by Luigi, your colleague, Marianne Bertrand, and her co-authors, A Hall of Mirrors, which suggests that much of the apparently, or at least prima facie participation in the notice and comment process by nonprofit entities is actually being undertaken by for-profit entities. So I will stop there. I hope that gives you something, but I do want to emphasize, I think it's the Stigler's contribution to the value of science was crucial, because what we now need to do is focus on more nuanced, institutionally rich theories of special interest influence and regulation. And I'm not sure we'd be doing that were it not for his seminal paper.
Thank you very much, Dan. And continuing, yesterday we heard Sam Peltzman, who is in sort of a hierarchy, the direct descendant of Stigler on this front, saying that two things that I thought were very interesting. He said many things were very interesting, but two in particular. One is that he thought one of the main contribution of George Stigler was to challenge the public interest regulator. But then he added pretty fast, this figure is back periodically. And I have to say that after hearing the short speech by Cass Sunstein, I think he's back. And this is, Cass really believes in the public interest regulator. So my first question is, to what extent this is reliable, to what extent is excessive, to what extent George Stigler's position was excessive? And related to that, Sam Peltzman also added that we need to really develop a new theory of regulation. I think that Jennifer correctly pointed out that the title of George's article was much more narrow than we made it to be today with economic theory of regulation. And I think that maybe we have to develop an economic theory of regulation. So starting with you, Richard, how would you answer these two questions? Number one, can we rely on public interest regulation, or Cass Sunstein is a bit too optimistic there? And two, what pieces a new economic theory of regulation should have that are missing?
Well, look, I think what happens is anybody who believes there's an homogeneous, uniform response to that particular question tends to understate the extreme variation that starts to take place amongst various agencies. And they also understate the importance that particular statutes can have in the way in which things are done. So, for example, to give you something where I think industry capture is done by the agency, often against small companies. If you look at the Dodd-Frank Act, what it did is it created a procedure whereby the commissioners could decide to appoint people to adjudicate particular charges, so that what you have is industry people punishing guys. They act as both judge and jury and thing. And it turns out that those cases can really have devastating effects on individuals because the capture that you're going to start to be taking place is in fact by the agency itself, and you're never quite going to figure out who it is that they want to get or not. And sort of figuring out the battle as to where these things are decided becomes critical. And Dodd-Frank Act and other legislations, the American Invents Act, both have created a willingness to have greater intra-agency adjudication, which I think leads to massive forms of abuse because you don't see the separation of power. The other point that I think that's really important to mention is that regulation at these particular points in time is heavily sensitive to the change in administration. The Trump-Biden shift, the Obama-Trump shifts were there. It's even more than you might otherwise expect because what happens is you start to change the people who are running particular kinds of agencies. There is a sort of deference, not to a continuous learned tradition of one kind or another, but to the last decision that the last agency wants to make. The so-called doctrine of Chevron deference essentially encourages flip-flops to start to take place between administrations because you can never deal and claim a reliance issue based upon what a previous agency said when you're dealing with a new agency. This then creates the following serious problem, and I'll stop on this note, which is regulatory time horizons have gotten shorter, whereas investment time horizons are at least as long and maybe even longer than they used to be. And so simply the uncertainty that's created by regime change has become much more important. I don't think there was the slightest hint that George worried about that when he did his situation. He kind of treated the government as constant, even though that was clearly false. Roosevelt certainly was very different from the guy who preceded him and from the people who followed him. But nonetheless, I think the flip-flop has become much more accentuated because of institutional changes in administrative law.
Thank you, Richard. Jennifer, what is your view on these two issues?
Yeah, so let me just offer two thoughts on these questions. Okay, so one is, again, to the observation that many have made that Stigler didn't at all open the black box of these regulators. I think it's first important to appreciate different actors that are involved, even at the agency level, when regulations are being drafted and written. And in particular, to simplify, we can think of the differences between political appointees that flip-flop to Richard's theme amongst presidential administrations versus the work of the career civil servants in the agencies that, of course, are stable throughout time. And I think better appreciating the role that they have in the regulatory process, in particular, the observation that only a very small slice of regulatory decisions are elevated to political appointees. The bread and butter of regulatory work, whether it's adjudication, even the drafting of regulations, certainly the ones that aren't high profile, are done by career civil servants. And I think there, to Cass's optimistic view, I think it's well-founded, is that these career civil servants are not only more insulated from capture, but I think that to draw on public administration work, there is a real culture of thinking about their own institutional roles as serving the public interest. Now, of course, there are anecdotes to the contrary, and it's not, monolithic, but at least relative to political appointees, I think it's important to appreciate their role here, and therefore, maybe it is can vindicate kind of this idea that there is somebody in the administrative state looking out for the public interest. My second just thought on this, to connect it to Cass's points in some of our discussions here, this is something that Dan said too about, whether we could test potentially informational capture of some kind. And it strikes me that one thing, the paper hasn't been written, I haven't seen it, but perhaps it's out there, is to look at how regulations have changed with the introduction of cost-benefit analysis. And I think your hypotheses really depend on whether you buy Cass's view that cost-benefit analysis really serves public welfare, is public welfare enhancing, or if you adopt the progressive view of cost-benefit analysis, which is it's just a way for the industry to epistemologically capture the agencies because of its focus on costs and the information that's provided by industries. And I think work that would, look at regulations in different categories, pre and post the introduction of cost-benefit analyses, would help to shed some light on the questions that we've been discussing, and would very much be, I think, in Stigler's empirical tradition.
Thank you, Jennifer. Dan.
Thanks, Luigi. So again, with regrets, I was teaching during Cass Sunstein's lecture. So what I'm going to respond to at the moment is the mental model of his lecture that's in my head. And so in doing that, let me say, I think if the idea is that there is a viable public interest model of regulation out there, as an academic, I approach that skeptically. And I say this even as somebody who has been a skeptic of the Chicago School of Regulation. And the reason is as a political scientist, and I think this is very much consistent with the Chicago School of Political Economy, I think every regulation has to be launched and supported by some kind of political equilibrium. What are the votes for? What are the coalitions for? And I think that's absolutely crucial. And one of the real values, again, even where he was wrong about Stigler's model here, is that he said, look, here's a framework with which you can think about why there is a political coalition behind certain kinds of regulation. In this case, industrial forces, especially larger, older incumbent firms that are going to benefit, and or the industry as some kind of coalition that are going to benefit from the imposition of these entry barriers and or costs. If we're going to replace or move to a much more public interested world of a regulation, then as a political scientist, I want to know what the model of politics that's generating that is. And I'll repeat that maybe we need some kind of theory of Ralph Nader and how the coalitions come together. Most of our thinking from economics go back to Mansur Olson, but also to Stigler, is the kinds of coalitions that are going to support public interest regulation are not going to be stable. They're not going to be as powerful. The benefits are going to be diffuse. The costs are going to be concentrated, everything from Olson. And those are the kinds of coalitions that we shouldn't necessarily expect to be durable. On mechanisms, let me just, two other quick points. I think mechanisms are going to be absolutely crucial here as we look into. So if we want to come up with a political public interest story, I guess, again, I want to know what's the legislative sausage making process and or regulatory sausage making process that issues in those regulations, or if it's capture. So maybe Richard is right. I'm skeptical of certain aspects of, say, the Durbin rule on charge fees. But if in fact it is, yeah, he is too. So finally we agree on something.
Oh, many things.
But let me say that if we're going to say that was capture, then we really need a story whereby the mechanism isn't just, well, the agency screwed up and got it wrong. If it's a capture story, we need to say at some point interests were mobilized such that those who would benefit from the rule were powerful enough to have shaped it. And again, to sort of overcome the counterfactual that it wouldn't have turned out that way otherwise. But one final thing, I think Richard's point on time horizons is a really good one. I think Jennifer spoke to it as well. Part of what you get with merit reform is, like I'm talking about the Pendleton Act and all of its sequelae, are a set of bureaucrats with longer time horizons than they would have had otherwise, say in the 19th century. I want to say, however, that again, in some cases we have the opposite. So there's this big debate right now about whether the FDA should have, I'm not going to weigh in on what the right answer is, but whether the FDA should have approved, say, the Moderna vaccine in, April, or should have, accelerated a whole bunch of other things. The attitude of many FDA lawyers, food and drug lawyers, things like that, is to say what we really need here is institutional credibility. We want these things to have been tested by randomized controlled trials, phase 2 or phase 3, things like that. And the push in that debate on the side of the bureaucrats is actually for a longer time horizon than many of the FDA's critics have, which is to say, hey, let's just get this stuff out there now. I'm not going to weigh in on that global debate. I've done that with Tyler Cowen and others. But I do want to point out that important counterexample where sometimes the agency has a time horizon that's far longer than those of investors.
But then, if I understand correctly what you're saying, is basically what we lack is the political theory of formation of interest that leads to regulation. So it's really your field that is lacking here.
Oh, isn't that nice of you? Yes,
yes.
I agree with you. Look, I think political scientists have failed in general to come up, and economists, with why a whole set of regulations that were at least passed as if they were going to be public interest were indeed passed and were indeed implemented. The model I use in the FDA's case is one where, in part, it's kind of an endogenous institutions model, where you had already a regulator there that was, for better or worse, trusted. And when Congress went in 1938 and 1962 to tackle a problem, they basically delegated to an agency that the public trusted. I'm not saying that the public's trust was well placed. I'm not saying it was the right decision. I'm saying that as a mechanism, that does a far better job of explaining what happened. But even that's only partial. We still need to explain why these political, I would emphasize what's the coalition that gives you public interest regulation. If that's the direction we're going to go, that's the direction we need to go as academics to explain the mechanism.
Okay. Richard, I will give you the word in a second. I want to insert another element, because listening to the three of you, you seem to praise very much career bureaucrats. Coming from a civil law country where there are a lot of career bureaucrats, and there is also this institution called Consiglio di Stato, which is present also in Spain, in France, of these super powerful bureaucrats on administrative law, etc. I am a little bit less enthusiastic about all this career bureaucrats. So is it really that the solution is to have highly paid career bureaucrats? Because if they're highly paid, there is no capture. If they're career, there is no capture. So should we go in that direction, Richard?
No, I was going to start to talk about that. With connection with the FDA, I think its recent responses have been very bad, mainly because what it takes is the double-blind clinical trial, which works pretty well for drugs like cholesterol, and then tries to apply it with respect to various kinds of diseases when there's other forms of evidence which are much more reliable. That leads these career bureaucrats to be literally 20 or 30 years behind the time, precisely because nobody can dislodge them and nobody can persuade them. And so if you look in the United States, for example, there is no first-line treatment out of hospital that is made available for COVID, whereas around the world, ivermectin and hydroxychloroquine are in pretty wide use. We understand essentially which way the numbers go. Those countries do much better with these kinds of things than we do, because what we do is we take a model that works in one case and we don't apply it to another. The second point, to answer Dan's question, I do know something about the Durbin Amendment because I actually worked extensively on the litigation associated with that case. And the one thing I would mention here, which I think is somewhat of a surprise, it's amazing how much a single determined political force backed by a relevant industry group can get things done. Durbin is from Illinois. Walgreens is from Illinois. What Walgreens does is they said, look, we want to tell you something, Mr. Durbin. We have 4 sets of costs that we worry about. We worry about labor costs, healthcare costs, property costs, and interchange fees. And what we want you to know is we're being ripped off on this kind of stuff. So what they do is they kind of have an industry sort of populism. He gets this thing. He gets it through, by the way, not as part of the basic statute. He was very clever. He waited. It's called an amendment because he put it in at such a time where he gave people on the other side in the House, like Barney Franks, the very unpleasant alternative of trying to kill the amendment and then killing the bill or saking the amendment in order to get Dodd-Frank through the situation. So, I mean, we do have a kind of pretty clear political story there, and it's more like Bismarck making sausage than it is like a form of public interest regulation, because the outcome, which is a kind of a disguised form of rate regulation, has had such perverse effects on so many parts of the industry. It's almost impossible to have a normative theory that justifies that statute. But when it came to court, and I was very much involved in this litigation, the rational basis test dominated everything. And so if the Fed decided that it was going to respond in a certain way, that ended it. And what they did is they kept the regulations, but they raised the rates so as to make the industry livable without having a principle for first why they lowered them and then why they raised them. So this was very much an interest group play.
Thank you. Jennifer, can you try to answer to my provocation about sort of career civil servants and also the question about the pay, which I think is important.
Yeah, so first, let me just start off by saying that, like you, I think that rule by career bureaucrats, the prospect of that is frightening, because despite, I've written in support of them, but I do think that the criticisms of them are real, okay? That is to say, all the principal agent problems that we're familiar with, I worked alongside some of them, 5 o'clock, lights out, right? Can't fire them. A lot of them were useless, sitting in their offices, it's not clear what. That said, I think that the model that we have in the United States, which needs much reform, but I think the model that we have where politically accountable actors are at the top, supported by career civil servants, does have a lot to celebrate. And in particular, not getting too, abstract about it, I do think it promotes a kind of intra-agency deliberation within agencies, that hopefully the pushback, against the potentially captured political appointees results in different rules. And I think if you can see that anecdotally and empirically, if you look, for example, at the proposed rulemaking after for the Clean Air Act, after Massachusetts versus EPA, like 200 pages of clear career staff writing the rule, and you had political appointees actually dissenting, like in the proposed rule, saying we don't agree with this. But the point is that there was that deliberation. Second thing I just want to briefly say on this theme, which is, my earlier comment wasn't so much full-throated celebration of civil servants, but rather about institutional design, about thinking about places in the administrative state where similar kinds of insulation akin to civil servants would be useful, to Stigler's point, because it helps to mitigate the incentives for capture. So I've already talked about Article 3 judges. Civil servants is another example. Another example to continue to think about in our conversation and going forward is independent agencies. Okay, so of course, independent agency heads are removable only for cause. That is to say, they can't be fired at will by a president. And they have longer term limits to all of our themes about more of a stable government. And I think, to Dan's point about, having a theory of natorism, I think it really has to take into account why particular statutory authorizations are delegated to independent agencies versus executive agencies, and why independent agencies, succeed in passing more public interest regulations. I mean, that's an empirical question. And I think that too is testable.
So let me actually make a plug to a book that we discussed both in the podcast and also on the pages of ProMarket, which is Unelected Powers. There's exactly an attempt by Paul Tucker, an attempt to explain when do you have an independent agency and what are the limits of an independent agency. But what I don't fully grasp on your response is you take the United States as a model, but other countries have the level of career appointment go much higher and the level of political appointment lower. So should we go in that direction? Is it better to have sort of more career bureaucrats at a higher level of the administration?
What?
I think properly cabined, I think the answer is yes. And just to enrich in the US picture, okay, there is a whole level of civil servants in the senior executive service, the SES, which, to your point, Luigi, is more higher level. They're the managers of these agencies, and they are career. And I think, again, this is an empirical question, but that would be interesting to test. I think that the emergence of the SES too could potentially explain some of the emergence of more public interest regulation, again, because you have this cadre that is higher level. And then just finally, Luigi, to your point about lowering political appointees, right? Paul Light wrote the book about the thickening government, where he basically points out that political appointees are getting, thicker and thicker. And we've had a lot of reforms and statutes that have been passed that have actually thinned out political appointees at the top. So this is just to say, maybe there is a sort of convergence over time across countries in the staffing of government agencies, and maybe we can take that as evidence of good institutional design, ?
Thank you. Dan, I saw that you wanted to come in, please.
Yeah, so just on this point about careerists, it might seem as if we were celebrating them. I would say relative to a patronage system or some alternatives that we had, I'm happy to engage in the appropriate celebration. But I want to agree with Jennifer that one of the issues right now is the degree of, at least at the United States, top level United States agencies, is the degree of partisan appointees at the very top levels, folks who come in through the executive departments and stuff like that. There's sometimes communications staff, things like that. Exactly what service those folks are using, even for the purposes of political accountability, is not exactly clear. I think Paul Light is perhaps right that it's thickening government, and in fact, it's another form, very small, of patronage. But two other, I think, related points is, first, I think, remember that Stigler wrote about state agencies. And I think one important thing to keep in mind about the United States and some other countries is that at the state and local level, government employees are a powerful political force. And of course, we're seeing this in the current debates on teachers unions, police unions, things like that. Without getting into a big debate about the utility of those, I think we're having a much needed conversation in this country about them. Federal employee unions at the national level in the United States are far, far weaker. They simply don't have the ability to move the votes. Maybe in some congressional districts in Virginia and Maryland and some places out west, but not nearly the kinds of vote moving. And I think the other thing that it comes down to is picking your poison a little bit. career civil servants, whether celebrated or excoriated, have, in our system of government and many others, have the statutory authorities that a Congress or a legislature delegates to them. And, you know, to push in an emerging critique in my own discipline right now, I think what we need is either less delegation or far, far stronger legislative oversight. I mean, legislative oversight has withered in the past 3 or 4 decades, not just in the area of regulation. You look at the GAO, you look at the CBO, compared to the size of the federal budget, or you look at the major oversight committees in Congress. And this has generally happened at state legislatures too. The ability of the people's representatives to even engage in alternative fact finding and oversight is just immensely diminished compared to the situation we had 5 decades ago. Does that mean we're worse off necessarily? I'm not saying that. I am saying that if you're concerned about the power of careerists, I am. It's not simply getting rid of careerists, but talking about the kind of power that is given to them through delegation and post-delegation oversight that needs to be part of the conversation.
So Richard, I'm coming back to you, but there is a very interesting question here from the audience by Jay McLean that raises this interesting point. You are saying that this is competition between various interests, but this person is saying, wait a minute, because if you're a publicly traded company, everything that you say is can be basically challenged as a false disclosure at the SEC, and you have a suit, blah, blah. But if you have a private interest group, you can say whatever you want without any risk of any liability. And so is there a imbalance in this contest for shaping public policy between privately traded interest and publicly traded interest? What do you think, Richard?
I think it's oversimplified. There are many public companies which exert an enormous amount of influence. Sometimes they do it individually. Often they do it through trade associations, which is extremely powerful. So I don't think you can make any of these kinds of justification. The point that I would want to stress is somewhat different, and it's related to it. The question of whom you choose depends, as Dan says, on the amount of delegation you have. One of the interesting legal battles that's starting to take place right now, very inconclusive, is do we basically say that the old non-delegation doctrine, which required Congress to make certain decisions itself and not leave it to the agencies, will become part of American constitutional law. Elena Kagan is on record for saying, you do this, it's the end of the administrative estate that we know and love. Others people are much less skeptical. But the descriptive point is clear. The moment you decide to increase the indefiniteness of property rights, these things are up for contest. And the larger the number of rents that are out there to be gathered by somebody or other, the more steps that various kinds of groups will start to change. And so you can see this in virtually every agency that you're talking about. To give you but one simple advantage, if you look at something like the FCC, if the battles that you had under the FCC were simply questions to make sure that you policed interference physical at the boundary line, there's very little that can be done. But we have had from the very earliest time, we don't give people property rights, we give them licenses, they're subject to condition, they can be challenged on renewal. The renewal can be from groups that say, pay us off a little bit or we're going to try to slow this sort of thing up. And so the political economy, which was celebrated by Felix Frankfurter back in 1943 in the NBC case, essentially has given rise to this kind of situation. It's a kind of an art historical anomaly. When Hayek wrote about this at the same time that Frankfurter did, this was the difference in their reaction. Frankfurter said, look, it's the job of an agency not only to determine the rules of the road, but also to determine the composition of the traffic. Those are his words. And Hayek's position in the same year is the genius of a situation in which you have the rules of the road is everybody can get on there for their own independent purposes because the rules start to coordinate behavior without giving you that centralized situation. The difference between those two models, I think, gives rise to a lot of what Dan explained as to why it is that he's sounding much more like me, or is it me sounding more like him, have the kind of uneasiness that this behemoth has grown too big. And all of these key decisions were made in the 1930s and 1940s. None of them have been reversed. If anything, the tendencies have been exaggerated.
Jennifer, do you agree that this behemoth has become too big and we need to sort of undo it or in some way fix it?
Well, I certainly agree with the broad theme that Congress is, broken now, and really there needs to be more tools to assert more legislative oversight. I totally agree with that. I mean, it's a kind of an ill-defined question, right? What does it mean to become too big, right? You can measure that in a lot of different ways, right? Are we talking about like FTEs in government? I mean, we can't count the number of regulations because that's not really any measure of anything. So, this is not the answer you're looking for, but I just can't help but push back at the question, which is like, I'm not sure I know what that means. I mean, look, Richard's gonna look at me and say, well, what he means is it's just too costly. It's just too costly. And then I can't help but, point back at Cass's remarks and say, well, we don't care about absolute costs. We care about net benefits, right? We also have to have a measure of the benefits that regulations are offering. And I think that's really the only sensible way that I think we can answer that question.
But indirect benefits are impossible to calculate under many of these cases. And the claims are too big.
Yeah. The problem, I think, is exactly with the cost-benefit analysis, is that benefits are big, the cost very precisely measured. So if you want to say that everything is too costly, is easy to do because the benefits potentially are very, very large, but they are imprecisely measured. And the costs are limited, but very precisely measured. So that's where, in my view, the arbitrariness of the cost-benefit analysis, at least as I saw it apply, for example, to capital markets, is there. But Jennifer, there is a question that actually I need some help, because Giuliano Stanzani ask whether the Tauber's reflexive law is an effective approach to regulation design against capture. But you have to help me, and I hope other watchers, to explain what is Tauber's reflexive law.
What is she talking about?
Okay, so maybe as misspelled, so I don't know. I was ignorant, so I think that this is something that related to administrative law, but is not. Okay, so why don't we pass to another question by Henry Schultz that is charging Jennifer on what she's saying about the judges being effective against capture. What if the judges themselves are biased? Capture can work through the appointment process. Also, judges may be subject to more subtle mechanisms of capture, such as cultural capture. What is your view here?
Okay, two quick responses on that. So first, I think it's just important to clarify that bias is different analytically than capture. I mean, the two concepts are related, but I think one could think that they're not captured, but agree that they're biased. And I think that let's be careful about that too. I mean, I think bias could just mean coming in with very strong political priors. And I completely agree that the post-Bork judicial nominations process, where we have litmus tests for judges, has certainly fostered that culture. Are they captured? I mean, when you look at the profiles, especially of some of our recent Supreme Court nominees, I mean, prior judges, prior academics, and I think they come from these professions which culturally push back on industry influence, subject to, there was a discussion about, our academics captured. But generally speaking, I think that their orientation, at least as of late, is to push back on that idea. So I guess, look, it's certainly possible that capture can operate in that way. But, if anything, I think it operates more through partisan ideology. I think, to simplify greatly, those that are nominated by Republican presidents tend to be more industry friendly, either because of a philosophy or an ideology. And I think that is different than Stigler's theory of capture, where they're personally benefiting somehow from industry giveaways.
That's absolutely correct. The civil rights lobby, which was unheard of at the time that Stigler wrote, is one of the most powerful lobbies that sort of exists in Washington today. And it manages to express itself on every independent area of substantive interest. So, for example, I was asked to testify in New York, but this could happen anywhere else, to explain away the racist eviction policies that exist in the United States, which is why it is that we have to have these moratoria, which the Biden administration, I believe, has extended. The definition of discrimination now is not that there's a test that has got a disparate impact. It's that if you observe the phenomenon and there are more blacks than whites in a given category the other way around, that's virtually conclusive evidence of discrimination wholly without regard to cause. And that's a political movement which is much, much more powerful to deal with than the kind of economics that we're talking about. And it has basically infected all the financial areas. So you start looking at the kinds of rules that are being put up by NASDAQ on terms of who ought to become a member of its board and the diversity requirements there. That is not done out of business interests one way or another. It's done essentially in response to these forces. And as somebody who's generally been on the other side of this particular rolling pin, I can tell you these are more powerful, more coherent, more sophisticated forces than any kind of regulatory force that I had been asked to deal with in my over 50 years of teaching before the modern period.
So Dan, there's a question here that is definitely for you, and this person, Dario da Silva, raised the question, but what about direct democracy? Is it a solution or a curse?
So for the past 2 decades at Harvard, I've taught a course called What is a Republic? And I'm a skeptic of direct democracy. It's not to say I'm a skeptic of democracy. I believe strongly in a democratic Republican system. But my concerns about plebiscitary institutions are, number one, that 50 plus epsilon% of the people who show up on one given day can not only institute a new law, but can often change a constitutional amendment in deeply discriminatory ways from an economic as well as cultural, racial standpoint. We've seen this repeatedly. We saw it, by the way, in the actual progressive era, capital P. Second, the way the process is set up, there's not really a lot of deliberation or compromise. Basically, you vote for the status quo or you vote for the alternative. And one advantage, you could call it a disadvantage, I think it's an advantage of referring things to a legislature, is that even with open rules in a committee or closed rules for committee jurisdiction, you can end up with a number of alternatives that are entertained on the floor, to say nothing of committee markup. And so my view is that direct democracy generally, but also in the area of regulation, is not desirable. I will say Ohio has an institution that I think is worth looking at, which basically allows the people a veto of something that has already been passed by the legislature and signed by the governor. So it comes in only ex post in Ohio. This is what I know. Maybe they've changed the institution, and that you could say, oh well, that just gives the people the ability to undo something that has been carefully considered by the smaller Republican branches. But I like that as opposed to something which is initiated purely by petition, or the other way of putting this, I guess, Luigi, is to say I'm much more open to direct democracy if, one, it's governed by supermajorities. So you've got 2/3 or 70% of the people having to show up on that given day, and or number two, if it's purely ex post, which is to say that the people get to veto something that has already been passed by the elected branches.
It's ironic. I teach the exact same subject when I teach legislation, and just yesterday taught referenda. My position is actually very close to Dan's on this situation. I think it's important, though, to remember what the origins of this was. The referendum starts to come of age at the beginning of the progressive era, and it's done as a direct response to what was thought to be the domination of these things by large corporations. So in 1913, not a random year chosen, there was a case called Pacific Telegraph and Telephone, and the challenge was made that a referendum was inconsistent with the Republican form of government, because the Republican form of government in the classical political theory was in opposition to its degenerate form known as popular democracy with simple majority votes. Supreme Court refused to consider the issue, saying it was non-justiciable, even though it surely was. And so these referendums have gone off. And then the question then is, how do they do it? So I'll just mention one additional complication, which comes up in several modern cases, a case called Hunter and Erickson, in which a popular referendum is passed to override an anti-discrimination law. I'm against these laws in public housing, but that's neither here nor there. And the question is whether or not a referendum can be strong enough to say that the legislature cannot act on the same subject in the next generation. And the Supreme Court, after much agony, said it turns out that, by God, you cannot basically entrench the referendum as against the legislation, which is a strategy that is tried. And I'm sure that Dan would agree with that, not even having consulted him, but I think we're pretty much on the same side. Then the Schweddy case, which came up in Michigan about this stuff, there was a more dramatic challenge is somebody constitutionalized the colorblind rules on admissions. And this was challenged. And Hunter and Erickson was distinguished, but you can see what the issue is. Can you put this kind of thing in a constitutional
Richard,
stuff?
we're running out of time.
Okay, it's a real problem.
I know. I want to just a telegraphic expression from Jennifer. How do you fall in this debate on direct?
We are running out of time.
If I had to choose a side, I am very anti direct democracy in the process. I think it is antithetical to administrative law and administrative process insofar as I think can be arbitrary. It can be, the work of organized interest groups, and they often don't have to explain their reasons. So if you contrast direct democracy, the legislature and administrative agencies, they're at the bottom. That is, at least Congress, under rational basis review, can sometimes have to give some kind of reason for what it's doing. The petitions, they sometimes do have a rationale when you vote on it. It is true, but there is a whole topic of how that's interpreted later in the courts that I think suggests that the rationale is actually not a basis for interpretation. And then by contrast, the regulatory process really tries to counteract, I think, everything that not everything, but many things that the direct democratic process stands for.
Fantastic. I would love to continue the conversation, but we're out of time. And I feel that I should refer to all of you listeners to the YouTube channel of the Stigler Center, where you can find a lot of, actually all our talk, including one, for example, the presentation of the book by John Matsusaka called Let People Rule, what takes the opposite view of Jennifer on the importance of public initiative and referenda to fight capture. So there's plenty of variety of opinion, and you can follow us on ProMarket on the podcast Capitalism. And thank you, all you panelists, for a phenomenal panel, and all you listeners for sticking around for all this time. And I think the best tribute of a person like Joe Stigler is not a pure celebration, is a discussion, and I think we have celebrated him in the best possible way. Thank you very much.
Thank you.